she's
And it's
ready.
more accountability, right?
It's more accountability.
That's the thing.
Oversight and accountability. I think those are the key terms. So what I would like you to do, because I think this is going to be the easiest, is to pull out the form. It's about 3 to 4 pages that's entitled Board Findings and Rationale. Does everybody see that?
Yep.
Okay, we're going to go through that, and I will give some more detail as we go through it and do some examples of how that works. Before I do that, though, I want to talk a little bit about what is used to make your findings and recs. And that involves documentation. Being an attorney by trade, there's many types of documentation that a court consider on any case. And when you think of it, there are 3 types of documentation. And it could be in an electronic format or a written format, but there's 3 types of documentation. The first type of documentation is legal documentation. Legal documentation is the type that, the best way I can describe it is to think of anything with a raised seal. So the birth certificates, marriage license, divorce decrees, any certified copies, they all have that nice raised seal. And in an evidentiary standpoint, those of course are the highest. You don't have to lay foundation, you don't have to do anything within the court because they're authentic documents. We always look at those, correct? I mean, they're birth certificates. They're the actual document itself. Second type of documentation are reports that are dated and signed. So it would be that therapist that is meeting with the child that has completed a report and dated and signed it. They are the actual creator of the document, and they have dated and signed it. And we've always looked at those too, correct? I mean, those are their written reports. Third type of documentation would involve narratives, notes, minutes, things along that fashion. And the best way to think of those, as an example, would be the case manager that's in a family team meeting that comes in and then writes a narrative as to what everybody said. From a legal standpoint, that's that magical word hearsay, because it's something else a third party said that now they're writing down, which on a reliability standard is never as reliable. Because if you think about it, anything I say here tonight, you're listening to, you write it down, somebody else then looks at it, it was your interpretation of what I was hearing, not listening to me directly. That's hearsay. And so the question always comes up for our review staff and also for board members, well, do we consider hearsay? Do we consider this type of documentation? And in my opinion, and what we've decided as an agency, yes, we do. Because in Any More Today, there's some very relevant information in that. But, and it's a capital but, what needs to be kept in mind is what weight are you going to give that information? Because as you review documents, you're going to think about which you're going to give more weight to. And it's probably true as you review a case, some narratives you give a lot of weight to, other narratives you don't. If a foster parent completed a questionnaire that agrees with the narrative that was just given to you, you're probably gonna, okay, then that's right. If it's different, you have to decide which one you're really gonna give the more weight to. So what the review specialist has been told is they need to get all that information to you, because in order to make a good decision, you need as much information as possible. And then it is up to the local boards to decide how much weight they're going to give that actual information. Because sometimes there's not much weight, sometimes it's a lot of weight. And that when they do their findings and get the documentation to you, they need to tell you where they got it from. So it was from a narrative done on such date. Well, then you know, how much weight am I going to give that?
So are the reports that are dated and signed, would that include a physician's report?
Could be.
Or would that fall under narrative?
Nope, that would be a physician's report if it's actually date and signed by that physician or by that therapist or that psychological evaluation. Those would all be reports that are dated and signed.
Okay.
What about when we have participants at the meeting to bring us information that's significant? Does it then become document narrative when the,
Well, usually what they're giving you is
Writes it
oral. If they're giving you documentation, it depends upon who it's from. If it's a report that's dated and signed by that therapist, then it would be the second category. If it's their interpretation of what the therapist
well, I'm
said,
thinking more that they're reporting current happenings that are not in the case, not in our case material at all.
Right.
Like, we've had participants come and say, oh, he isn't even there anymore, he's been moved to.
They give us new info.
They give you new information.
might
Sometimes we
change our
have CASA
findings
workers and they
based
come and
on
they
that.
tell us something we didn't know at all.
right.
Yep.
But it's not documentation, it's oral. They're telling you
So I'm
oral.
just asking you, would it go under narrative or would you have another category of oral?
Well, oral is a different category. Oral is something, when you think about it legally, we all make judgment calls. So as that person is giving you that oral information, you are deciding, do I believe what they're saying? Are they telling me everything? Are they not? Because you're actually seeing that person and visualizing what it is they're saying.
And when we cite that in the document, in the final rec, we're putting in parentheses, foster parent at board meeting.
Yeah.
Right.
Right.
Yeah.
Mhm.
So that the most important thing that we can do for the courts and for the legal system is to make sure we're telling them where we got that information. It is your determination on the weight to give it, just like it's the judge's determination on what weight to give. So we have to make sure and let that judge know, this is where we got it. That foster parent was at the meeting and this is what they said. Which to me has a much higher level than what a third party reported to me. But if I don't consider what the third party reported to me, I might be missing a lot of information that I need to help make a good decision.
What I find really disconcerting is we get so many case reports that are written by the caseworker that are outdated, and all they did was go back and change the date. And you can read that, and you can have a kid in 3 different schools at the same time. I mean, and then you have to wade through, when was this written, when was this written, you know, it's really disgusting.
It is.
And all this conflicting information, and you have to try to figure out what's valid.
It is, and that's part of that, what weight
Yeah.
to give. And sometimes you reach the point where because it is so conflicting, I can't give any weight to it at all. Because it just is too conflicting. So I don't know what the truth is or what I need to believe. And then we need to say that also. Okay? The other thing I'd just like to mention besides documentation before we get into the actual findings and recs is with regards to safety. We all know in the abuse neglect system, safety is the prime consideration. And if we ever feel that a child is unsafe, we need to do something immediately. And we need to make sure the review specialist makes that phone call, we're reporting it, and because we have to be concerned about the safety of that child. So let's pull the findings. And you have this sheet right here that has them on. And what we tried to do on this form is let you know what the old finding was. When we changed these, we went to a numbered system instead of A, B, C, D, because our concern was if K changed, and you guys were so used to the old K finding, it would get too confusing. So we have gone to numbers. And I know we've done numbers before, and then we did letters, and now we're back doing numbers. The numbers also give us some flexibility to add or change things too, to add different findings. But as we put these findings and rationales together, what we really tried to do was look at a case from the very beginning all the way through it. So as you are reviewing it by a local board, you're looking at each of the pieces starting at the beginning and following the case through. We've also divided some things out. So what I'd like to first start with is finding 11 that deals with reasonable efforts. We know under statute we have to make 2 points of reasonable efforts findings. Finding number 11, which deals with the removal. Were reasonable efforts made prior to the removal of that child from the home? Finding 40s deal with are reasonable efforts being made towards the permanency plan. So let's take a look first at finding number 11. Reasonable efforts to prevent a child's removal from the home. Remember, as we're looking at this finding, we are looking at the most recent time that the child entered out of home care. We know through our data that we have a reentry rate into out-of-home care in the state of about 39%. So we are looking at the most recent time. And you guys are welcome to take notes, and I'm not discouraging that at all, but it also is in the big book here with all the explanations. So it is up to you.
We're gonna get a big book too.
You can get a big book too.
I don't know if I want
You
one. Sounds cumbersome.
But also remember, as we're looking for the reasons for removal, we don't always have to agree with what the judge found. Now, I do say, if we don't agree with what the judge found, then we probably need to give reasons why we disagree, okay? So 11-1, HHS made reasonable efforts to prevent the child's removal or could not have prevented the removal. In other words, it was an emergency situation and they had to make the removal. They didn't have an opportunity to do any type of reasonable efforts. Or yes, they tried reasonable efforts. Because we know many cases come into our system because law enforcement goes out to the house, they feel the kids are unsafe, they immediately remove those kids. That's an emergency situation, you could not have prevented the removal. So that's 11-1. 11-2 is that they didn't make reasonable efforts. There's no documentation, we don't know why they were removed, we don't know what they did before they removed them. 11-3 is when we make a finding that HHS was not required to make reasonable efforts to prevent removal due to aggravated circumstances.
Explain that.
The key to that one is the judge has to have made a finding in his order removing those kids, that it was aggravated circumstances. Because under statute, there are only certain things that are considered aggravated circumstances. Abandonment. So the mother goes to have a baby at the hospital and walks away and leaves the baby at the hospital. That would be aggravated circumstances. Torture, chronic abuse, sexual abuse, murder or manslaughter of another child, or aiding and abetting of a murder or manslaughter. Last one is serious bodily injury. So it has to be something very severe.
When they take a baby away at the hospital, because they've had previous, they had previous kids from that family and they know the parents don't parent well, that comes under?
No, that would not be aggravated
That's
circumstances.
something different, but
That-
they do that sometimes.
They do that, yes, but that would not necessarily be aggravated circumstances. I can tell you one case where, and this is used very rarely by the courts. I can think of one case where it was done. It was a case that I had where we got this is when I was in the county attorney's office, we got a call from a hospital that they had a 6-month-old baby there with 18 broken bones. So the judge, at that original order that I submitted to the court to remove that child from those parents, did find it was aggravated circumstances. And what that means, the key is, you don't have to do reasonable efforts to reunify. I could go directly to termination of parental rights. So that's why this is very important, that if you're going to make that finding, the judge has to have made that finding, because then that county attorney should be terminating parental rights immediately. And in that case, we did go right to termination of parental rights. 11-4, the last one, there's insufficient documentation to determine whether or not. So again, on this one, the key is if it's an emergency situation, then it's always 11-1. If it's, like we see more and more now, if it's a voluntary case where Health and Human Services has worked with that family on a voluntary basis, and then they end up filing in court and want the child removed, they better have done reasonable efforts prior to removing that child. All right? Any questions about that one?
And I just wanted to stay too with Myrna's observation there about the hospital. And when the child has been removed before, they've done all these services before, termination of parental rights on the other children, so they don't have to.
Right.
They've already done
What about
reasonable efforts.
OJS cases? Which one does that come under?
What we are going to be doing with delinquency cases, as of July 1st, all new delinquency cases are going to probation, no longer OJS. As of June 30th of 2014, OJS will no longer exist, other than the YRTCs in Kearney and Geneva. Everything will be handled through probation. So what we
Will it
are,
still be in our caseload?
Yes, they will be. But what we are working on, because to us, it made more sense, the findings and recs that we are dealing with tonight and talking about are only for 3A abuse neglect cases. We are creating new findings and recs and a data form for probation and status offense youth, because they will all be in the probation system now, so that they're different. When you're looking at OJS cases, or i.e. delinquency cases, you're looking at different factors. You're not looking at permanency plans and all that. So we're going to create new ones. So you'll get more education in a couple of months after we've created those. So yes, we do have a statutory obligation to review all probation cases for children that are placed out of home. And right now we're working with probation so that they can start giving us that information on a daily basis. So finding 21, appropriateness and safety of current placement. Now, the key difference here is that safety and appropriateness need to be assessed separately. Because that child could be in a safe house, but because of whatever we found, we don't feel it's the appropriate placement of the child. In other words, I'll give an example. The child is placed at a treatment facility. And we know the child's safe at the treatment facility, but we really don't believe, everything that we've seen, that that is an appropriate placement for that child. So there are really two different thought processes we need to go through. Is it safe? And then secondly, is it appropriate? Or you could have the opposite occur too. Say that the child is placed with grandmother, who is appropriate, but she might not be safe. So we decided in finding 21 to divide it out between the two.
Is 21-4, is that worded correctly?
No, it sounds weird. I think they left
I
out the
think we
word
missed some
B.
words.
I think we left out a word.
Left out B or something.
I think I'll look on the big one, because I think we left
Safe,
out a word.
but may not be at an appropriate
Not
level.
would be, make a big
But may
difference.
not be at an appropriate level, is that what they're trying to say?
Yeah, it's not.
May not be at an inappropriate level. Current
I think you just take the word
placement
may out.
appears safe.
The current placement appears safe, but
And-
at an inappropriate level.
That sounds good, but why don't you just say it simpler? Just say that it's inappropriate.
You can say that too.
Well, you need to say both because of what you were saying.
Right.
Safeness and
Right.
appropriateness.
It's safe, but inappropriate.
Because remember too, that we can't assume a placement is appropriate. We can't assume it. The other thing that we have to bear in mind as we look at placements is we have to look at statutorily what is the least restrictive placement for that child. Common example that usually comes up in that situation is if a child is placed at a group home, do they need to be at a group home, or would be a more appropriate placement be in a foster home? I am one of those people that believe very strongly that children go best in families. That family setting is really what we should be striving for, even though we know not all kids can. But really, some type of family setting is the least restrictive alternative for placement. So,
Sometimes we use this one when they have a child that's gonna be free for adoption and he's not in a permanent placement.
yes.
I mean, it's a safe placement. Then it becomes a really hard call because maybe he's doing well there and he's been there a long time.
Right, but it's not an appropriate placement. It may be safe, but it's not appropriate because they're not going to provide permanency for that child. Because really what we're trying to look at is this particular home appropriate for this particular child? Because you could have 3 foster youth all placed in the same home. And 2 of the children are doing extremely well there and it's appropriate and safe, but for that third one, it just isn't working for whatever reason. So maybe it's not appropriate. So we're not making a judgment on the foster home or on the placement as much as for this particular child, this is not the particular placement that's best.
So is 4 the new one, 21?
So we look at, first, is the placement appropriate and safe under 21-1? Second one, 21-2, that the placement appears unsafe and therefore inappropriate. And if it is unsafe, then we need to recommend immediate removal from that place. Third one, that due to lack of maybe documentation or home study, we can't determine if it's appropriate and or safe. Fourth one, the current placement appears safe, but it's at an inappropriate level. And it may be because they haven't looked for a relative. We know as a system we do not do a great job of looking for relative placements. So if we're reviewing a case and they haven't even looked for a relative or kinship placement, this may be one that we check, because they haven't looked for a potential relative placement. If we're going to remove children from their family home, if there's an appropriate relative that they know, or now under statute, kinship and child-specific placements are back, it's somebody they know and are familiar with, that is much less trauma on that child than going with somebody they don't know. 21-5, that the placement is safe, but it's inappropriate, and we explain why. Or 21-6 is for those youth that we deal with that are on runaway status. In other words, they're really not in a current placement right now. Any questions about that? So we've talked about preventing removal, their current placement. The next big area then are services. And what we've done in the services, it was formerly the C1 and C2 finding. We've really divided the services out into different questions and areas. So we'll be completing services out with regards to the mother, with regards to the father, and with regards to the child. And what that also means is if you have 3 fathers, you will be making services findings for each one of the fathers. And if there's children, you will be making findings for each one of the children, so that we can collect that and gather that better. Instead of, well, there's 5 children and 4 out of the 5 are okay, but 1 isn't, so what do we put down? How do we do it? We're going to look at it differently.
So there'll be one of these for each one of
Yes.
those.
Yep. There'll be 1 for each. So when you look through these, we've really divided it also into 2 different sections, because they're 2 different issues. The first issue is, are services being offered appropriately? The second issue is, are they compliant with the services? And we wanted to separate those out, because otherwise it becomes very hard to see, well, is it not working because they're not offering the services, or is it not working because the parent isn't using the services? So if you look, just like for under mother, 31-1, all services are being offered, and again, we have all underlined. Some services are. Services are not being offered. Services regarding the mother do not need to be offered. Maybe the mother's relinquished her parental rights, and we don't need to offer. Maybe the judge has already made a finding that reunification is not needed, and adoption is the permanency plan, and we don't have to offer services to the mother. And last one, of course, that there's a lack of documentation on which to base a finding. So that we're looking at, is HHS or the case manager doing their job in getting the services arranged? Second piece of it then, when you get to 32-1, then we start looking at compliance issues. And we've divided these out because we know, hearing from local board members, that they struggle in this. So mother is compliant with all offered services, or mother is compliant with some offered services, or they're not compliant, or they don't have to be compliant. Again, maybe their rights are terminated, or they don't have any court orders, or there's lack of documentation. So that way we can start to decipher out all, some, or not. Any questions about that piece? And then when you go to then services for the father, I want to talk a little bit about the form that I handed out, the fact sheet on paternity, because this is a big struggling issue on paternity. Both federal law and state law requires that within 30 days after a child is removed, they're to be locating the father. We know that's not happening as a system. One of the things we do need to key on as an oversight agency is ensuring that those barriers are being put front and center, that paternity issues have not been addressed with.
Why
Or the-
isn't it happening?
It's just, I personally think what happens a lot is that whoever the parent they were removed from is who they concentrate on, and they forget that there's another parent out there until things aren't working out to reunify with that parent. Oh, now we have to find the father.
Sometimes they're pretty hard to find.
Sometimes they are, but they need
The
to
one
show
night
at least,
stand.
right, they need to show reasonable efforts that they're trying to locate.
Right.
Just ignoring it isn't gonna make it better, as much as some of us like to hope it will. So proving paternity. I've got to divide this into two categories because legally it makes a difference. So the first category is you have children who are conceived during a valid marriage. When a child is conceived during a valid marriage, there is a rebuttable presumption that that husband is the father of that child and his name goes on that birth certificate. He is the legal father and remains the legal father until he steps up into court and proves otherwise. Because what we see coming up in cases is where a gentleman is named as the father, it was during a valid marriage, and then later mom comes forward and says, oh, he's not the dad. No, he's the legal father. Legally, to do an adoption or to complete permanency, you have to deal with the legal father. He is the legal father. Does that make sense? All right. So second situation, for children not conceived during a marriage, gets a little bit more difficult. There are two ways to prove paternity to become the legal father. If you haven't done one of these two things, you are what we call a putative father. You are an alleged father. Sometimes you will see in reports, they call them the biological father. In other words, they're not the legal father, they're the biological father. Sometimes we don't even know if they're the biological father. So, how do you then become from the putative father into the legal father? There's only one of two ways. The first is the gentleman signs an acknowledgement of paternity. He has so many days after he signs that acknowledgement of paternity to revoke it. If he hasn't revoked it, he then becomes the legal father and his name is put on the birth certificate. Second avenue, if the gentleman doesn't do that, is through a paternity action through the court. Then DNA testing is done, and the court enters an order that says he is the legal father. So you've got to do one of those two things for somebody to be considered the legal father. So what we're looking for on our recommendations is if we know who the legal father is, then he should be offered services or that child should be with that legal father. If that father has not been identified, or they haven't gone through one of these to show they're the legal father, then we should be stressing you need paternity testing done, we need to find out who this is, and we need to be advocating for that part of the system to work. Because otherwise we're going to stall that case out for longer and longer because we haven't done that paternity action to determine he's the father. Now what you run into then are of course those cases where the gentleman doesn't show up or you can't find him. And mom alleges 3 different people that might be the father. The way it works in juvenile court is HHS has to try to find the 3 of them, give them notification that it's alleged that you're the father of this child. If they don't step forward and do anything or come into court, then they don't have any legal rights to that child. What we see where the rub comes in is they don't do anything for a year or 2. And then many times what I would see is mom's parental rights are now terminated. And then all of a sudden this gentleman steps up. Oh, now I want the child. I am the dad. But the problem is that it's going to stall that case out. Because now you have to get that paternity testing done and that court order saying that he's the father. Before you
He
can
also
find
has to prove that he's capable of being a decent father.
Well, that's the next step after you've even proved he's the father. So first you need to establish he's the legal father, and then you can make a determination what needs to be done from there.
There's no time frame on that. I mean, they can come back 2 years later.
Yep, they can come back. Now, the acknowledgement of paternity, there is some time periods on that as to when somebody can sign an acknowledgement and all that set by statute. But as to a paternity action, that can be at any time. So we do need, that's why we as an oversight agency have to push that issue all the time on these cases up front, in my opinion. Because in fairness, even assuming, let's assume the child goes home and is reunified with mom. She's entitled to child support. She's entitled to all the benefits. We're doing the mom a service also in doing that. So it isn't just something you do for juvenile court, it's also something you're doing for that child. And you know then once you're a legal dad, Social Security benefits kick in along with child support. I mean, there's a lot of legal rights that kick in. So we as a system should be requiring that the second those kids are removed.
And adoption, what if the child is being adopted? And until all the fathers are found and acknowledged, adoption can't go forward?
The adoption can't go forward if you have a legal father with parental rights up there. The adoption can go forward if there is no legal father and nobody has stepped forward and you've published notification giving them an opportunity to step forward.
And
Because
if then when they come, okay.
then if they don't show up, then that adoption goes through. But you have to give that notification to say, it's happening, it's your last chance.
Period.
There's a time period.
Yeah, right.
Yeah,
Days or
it's
something.
not like they can come back 2 years later.
No, no. Not if you've given the proper notification and published it and tried to reach that putative father, then it all falls on him, because he didn't step forward within that relevant time period. So, no, otherwise adoptions would become a nightmare. So, that's why they do that. Okay, so any questions? Uh-huh.
We've had some cases where paternity was established, but no child support had been ordered. So what's the time frame, or what's the process of once they get paternity established? And then also ordering child support?
I think they should order it, well, as soon as the child goes home to the mother or to the, then they should order child support. And they're not very good about doing that in juvenile court. They don't, we don't do a good job as a system going in and doing that. And you really should. We should, and it has not been.
And if a father signs an acknowledgement and it turns out it's not father, I'm trying to, is there a way, okay, I'm sure in this reading, can he change that, or can that be
He can
changed?
change it, just like a child can serve during a marriage, but he has to step forward, bring a court action, because there's a rebuttable presumption he's the dad. He has to go into court, prove he's not the dad, and then the court will
That's
enter an
what this
order.
is.
Yes,
That's what all that says.
yes, that's what all that says. So yes, there is a way, but again, it requires affirmative action on his part. It just doesn't happen with him stepping forward saying, I'm not the dad.
Yes, good.
Correct, correct. All right, so next ones. Findings 41. Now, this I want to give a little bit of background on, because we've divided this up because it got very confusing. So we are looking at first the plan that HHS has submitted with regards to the permanency objective. And then the next ones are going to look at what are the court-ordered permanency plans, and do we agree with that? Because the way it works is the department submits a report and recommendation as to what they feel the permanency plan should be. Then you go to a hearing and that judge could say something totally different. And whatever that court order says is what everybody has to do until it comes back to court again. So we want to look at both parts of that do we agree with the plan submitted by Health and Human Services? And then do we agree with the court-ordered permanency plan? Because it can be different.
So the plan should change after court changes it. If the judge says, no, it's got to be a different permanency or whatever, then the plan should change accordingly.
Correct.
But it doesn't always happen.
It doesn't always happen. Now, what it does mean is that HHS has to follow that court order and provide those services based upon that plan. But that doesn't mean when that 6-month review comes back up, that Health and Human Services can't submit another plan saying, we're still fighting for this and feel it should be that, which is understandable. We have some areas of the state that don't like concurrent planning, so they'll never do concurrent planning. And what Health and Human Services does in every case is they recommend it, knowing that the judge isn't going to order it. But we would first be looking at, do we agree with the plan submitted by Health and Human Services? So when you look through these, they're pretty much like findings F. And we've divided, and I, that were previously. So was there a completed plan? Or no, it's incomplete? Or no, it needs to be updated? Or no, there's no plan? And then we're going to look at the quality of the plan by HHS. In other words, did the plan evaluate the safety of the child? Or no, they haven't evaluated it, or no, we can't determine. Make sense? Okay, then what we're going to look at is the court-ordered primary permanency plan. What did the court order?
Wouldn't it make sense to look at that first and see if the DHS plan follows it?
Well, but see, you're going to have some cases that haven't been to court yet, so you don't have a court order. All you have is,
Oh, that's right.
is the plan. So we felt we had to do the HHS plan first, then look at the court order. And that's why you do have an option under the court-ordered primary permanency plan. If you look at 51-4, it talks about that we cannot determine whether it's appropriate, and it might be because the court hasn't entered an order yet. So we don't know what the court's going to order. And then we gave also 51-6 that talks about it might be a non-court case. We are finding non-court voluntary cases where children are placed out of home. We're not going to have a court order then, so it's going to be because it's a non-court case. But basically, these follow pretty much the former H finding. It's appropriate, the court ordered. It's not appropriate. There hasn't been a court order in the last 6 months. What we're trying to capture here, are courts really having hearings every 6 months like statutorily they're supposed to? Or we can't determine it, or maybe it's no longer applicable. And then the next set of findings deal with the former J finding. And this is where we're looking at, okay, we know this is what the court-ordered plan is. Is HHS making reasonable efforts to comply with that plan? So yes, they're making reasonable efforts, or no, they're no longer working to it, working towards the primary permanency, or HHS is not making reasonable efforts, we cannot determine it, or it's a non-court case. So again, now we're looking at what is HHS doing. Are they following that plan and offering the services? And again, the key here that I want to stress is we are looking at the primary permanency plan. So just that one first. Okay, 53-1, that area deals with, and it's a former G finding, where now we're looking at progress. So first we look at, is there a plan? Then we look at, are reasonable efforts being offered by HHS? And then we're looking at, okay, is there progress towards that plan? So in other words, progress is being made, no progress is being made, or it cannot be determined. What we're really looking at progress is for the previous 6 months. Because if hearings are being held every 6 months, we just need to look at the previous 6 months and is the parents making improvement. A couple of things that I want to mention here. Progress is forward momentum. It doesn't mean the parent has to have finished everything, but they're moving forward. They maybe have entered drug treatment, but they haven't completed it. That's progress. You also have those situations where, yes, the parent did a parenting class, but they jumped through the hoops and they didn't learn anything from it. That's not progress. So some of it is trying to ferret out, have they learned and are they making forward, or are they just jumping through the hoops? Which sometimes it's hard to ferret out, but by looking at all the documentation, hopefully we can.
What if they go to one, okay, they go to one class? and they don't go to-
I'd say no progress.
Could you repeat that?
If they go to one class, say that they are court ordered to do a parenting class and they go to one and none of the rest. No progress. They started it, but they stopped. Or they're supposed to attend 2 AA meetings a week. They attend one. Probably not progress. I mean, it's a step forward, but not very much of a step. So these are judgment calls that we need each of you to make. Do you feel that the parent is making progress?
And looking at all collectively, so they may not doing well here, but very strong in other ways, and you just have to weigh it all out in terms of what's,
We often go some progress or
Mhm.
little
Yeah,
progress.
exactly.
but It's hard to just lump it under yes progress or no progress.
Right. But maybe some of that instead can be looked at with regards to the services and progress on the services. I think you can bring some of that out, being we've divided that out on, they're complying with all of it, some of it, that can be ferreted out there, which might make it easier than try to figure it out here. Does that make sense? Margie,
That's good.
Correct.
Yeah, that helps.
So the next area is an addition that we've added. We have, as an agency, have never really looked at concurrent plans. And you know, many of the cases that you look at have reunification as a primary with a concurrent plan of adoption. And we don't collect data or information on that one, and I feel we need to. Because the law is very clear that if you have a permanent primary and a concurrent, reasonable efforts apply to both. You don't do reunification until it's not successful anymore. Okay, now we're gonna do the concurrent plan. They should both be going down the same pathway at the same time. And we need to look at reasonable efforts for reunification and reasonable efforts for that concurrent plan of adoption. What are they doing? Does that make sense?
Wasn't that gonna be hard at the end when you do barriers? Because you do barriers to the permanent development plan. Will you not do the concurrent barriers to the concurrent? Because if one was
I think you'll do both.
that and one was that.
I think you'll do
how would
both.
they do that?
Because say that the concurrent plan is adoption and they have not dealt with paternity at all. How can you ever have adoption until you've dealt with the father? To me, that's a barrier. So I think the barriers will apply both
Then
to,
you'll put in
to
two
both.
groups of them in.
Yes, and I think it does apply.
That'll be different, yeah.
That will be, but I do think we need to look at those concurrent plans.
and the
You know.
barriers you're gonna be doing are a little bit different.
Right.
And we'll talk about that later.
So when it comes to the concurrent plan, that starts at 61-1 and 62 and 63. It's the same type questions as we used in the primary. It's just looking at that concurrent plan. Because I do think we need to push that issue forward. I mean, have they found family? If that child isn't in a permanent placement and they're recommending adoption, then you better be out there doing family finding, trying to find some permanent placement for that child. You don't wait. I mean, there were many cases we've just reviewed lately where the kids have been free for adoption for 2 or 3 years and now they're trying to find family and to see who can adopt them. That's not acceptable. It's not acceptable. So we need to help push the system forward on this concurrent planning. Next section deals with visitation. And it was the former K finding. And what we've done is we've divided visitation down by parents. So let's first look at the mother's visitation. It's occurring, it's not occurring, there's a no contact order. We can't tell whether or not it's occurring because there's no documentation, it's a little bit hard. Or maybe visitation with mother is not applicable because her rights have been terminated. But then we'll look at the father separately, is the father. So there might be separate L findings for the father for each and every father. Because if you have 3 children, you might have 3 different fathers and 2 of them might be visiting and 1 isn't. So we will be doing findings for each one of the fathers, because I think otherwise we don't get a true picture, because you might have 3 children, 3 different fathers, 2 of them end up going with their father and 1 ends up being adopted.
Yeah, it does get weird. What about, like, they're not the father, but is that what they would be, we've run into this.
Or they're not the bio father.
They're not the bio father, but they've
stepdad,
always been there,
stepdad.
so they always refer him to his father. I would always think, well, he's not the bio father, so how can he really be, you know what I'm saying?
Well, he's not the legal father,
Yeah.
but that doesn't mean, I mean,
Moms.
sometimes you and I know, we've seen cases where the stepfather is very active and very appropriate.
Right.
And probably should have placement of this child. Then we should be advocating, not necessarily for visitation, but placement and even permanency with that stepfather. So let's do that and have them adopt the child, because nobody else is stepping up, and that's who the child has a relationship with.
And if there's no
But-
bio father in the picture, can we do the findings on that stepdad?
I think then you would make sure you have your review specialist write in that it's as to stepfather.
Or whatever.
But we have difficulty with data collection then. So that's one of them we know is gonna come up, that we're trying to figure out how we're gonna collect some of that.
Right. But
But
you
it-
are gonna build in that if there's more than one father, and if there's more than one child with different,
Right.
Keep in mind that we can only make one finding, because we're making that finding based on, if there's Johnny, Jimmy, and Susie, and they each have a different dad, you may have 3 different L findings, one for Johnny, one for Jimmy, one for Susie's dad. But you couldn't have 2 for Jimmy's dad. You could only have 1 finding.
Right. I mean, there's only one legal father.
and I'm jumping to when the kids are on different tracks, and so you can't make one answer for all the kids.
Right.
Then that's kind of a similar situation where you have separate findings.
For the kids, for each
Yeah.
child. Because kids are different, and a 16-year-old might have a different permanency objective, different everything than the 2-year-old.
Because we were always writing in, we were doing double answers.
Yeah, I was
Okay,
saying
for
that.
the mother, or for.
Like one was for this one and this one, the other
That's
one
what we
was for
did.
this one and this one.
Right, so we're trying to separate it out so that, first let's talk about Jimmy. All right. Then let's talk about Susie and figure out with regards to Susie.
So we'll have each one of these 3 sets, even
Probably.
though they're on the same case, okay.
Right. Because for our purposes, it's the same, what they call master case number, or same,
Right.
so it will collect it, but we have to be looking more individually at children and at parents and at family, because they all get treated differently. Then the last part of finding in the 70s is 73, and that deals with sibling visitation. And again, that's based on the former M finding. And remember that sibling has a pretty broad definition also, because that includes step siblings, half siblings. It's whoever that child considers is a sibling of theirs. They should, under federal law and state law, be entitled to visitation. And HHS has a responsibility to do it. The other key, I think, in this one is don't assume that that sibling visitation is occurring during parental visitation, because that isn't always the case.
Right, it needs to specifically say that.
It needs to specifically say it, because sometimes parents do not visit with all the kids at
Right.
once, sometimes they do. It's very different, so we can't just assume that. So that we've made some changes to the language in 73. The first one is the child has no minor siblings. The second one is that the child had no pre-existing relationship with a sibling. It could be that they have a half-sibling in New York, but they've never met and never seen. So even though they do have one, they've never seen and they don't have a relationship with. Sibling contact is not occurring due to a court order prohibiting contact, because sometimes there will be court orders saying Johnny and Susie should not see each other. Siblings are placed together. Well, if they're placed together, then they are seeing each other, so we don't have to worry about it. Or maybe regular contact is being facilitated with the siblings. Maybe it is all 3 kids are going to visitation with mom at the same time 3 times a week. Well, then they are having sibling visitation, it's occurring there. That it's not being facilitated, the sibling contact, or there's insufficient documentation that we can't determine. Right. Now, the last two, the finding 81, need for out-of-home placement, that's just like the former N finding. This is one we statutorily have to do. Is there a continued need for out-of-home placement? And again, you have to think about this, for me, by child. Because it might be that one child needs to remain out of home, but there's two other children, no, we feel they can go home. We don't have to think of them all, it's either all kids home or some. Because I've had cases where I think it's been more successful in reunification where we did not put all 4 or 5 children home at the same time and overwhelm the parent. We maybe started with 1 or 2 of them for 60, 90 days, and then we would put another child home, just because of all the changes that occur in that family. So we really need to look at that individual child, is out-of-home placement appropriate or not. And then findings 91 deal with TPR and alternative permanencies. And these are based upon the O and P findings. And I think most of you are familiar with those. There really isn't a whole lot of change. We've divided them up a little bit easier for data collection purposes. So return of the child is likely or possible, or 91-2, it's not likely and we recommend adoption, or 91-3, it's not likely and we recommend guardianship, or 91-4, it's not likely and we recommend placement with a relative other than adoption or guardianship, and then 91-5 is independent living. All right. And the grounds for termination really haven't changed. They are still the same as they were since 1996 when they were changed. But the one thing I just want to remind is that when it comes to termination, it's a 2-part test. You have to show one of the statutory grounds and it's in the best interest of the child. So just because you can show that the child's been out of home 15 out of 22 months doesn't necessarily mean that termination is going to happen. You have to show that it's in the best interest, or that you feel it's in the best interest of that child. Because there's many cases that you might review where the child's been out of home 15 out of 22 months, but really the mom's making progress and we're just not ready, then it's not in the child's best interest. Or it might be that 16-year-old that still has a relationship with mother and mother's making progress, and yes, the child's been out of home 15 out of 22, but it's not in the best interest of that child to do that. So always remember it is that 2-part test that you need to look at. So any questions about the findings? Because what I'd like to do next is to have you, did you get a copy of the big booklet?
No,
Mary, could you grab her one?
I can grab it.
Because what I would like you to do is to turn to the big booklet, and if you go to page 29, this is a new data form collection on the barriers. What we have changed within our system was you guys would do a wonderful job of looking at barriers. But we didn't necessarily do a wonderful job of collecting those barriers to be able to push it forward. So we have added onto the data form all the different barriers. And if you'll notice, what we've done is kind of divide the barriers up by topics. So the first one up in the upper left is issues regarding finding the parent or giving notice. And you'll notice we have mother and we have father. So whereabouts are unknown, or not identified or proven to be the parent, or parent not notified child in care. So when you asked about the primary permanency plan and the concurrent, you would be able to fill either one of these out, okay? Then right below it are issues impending the parenting by the legal parents. These follow pretty much the barriers you're used to. Maybe it's aggravated circumstances, or there's communication, language barriers, continuing domestic violence, substance abuse. You know, they need time to complete services. But again, we're looking at the mother. What are the barriers to returning home to the mother? What are the barriers returning to the father? And then if you go on the upper right, it says issues regarding Health and Human Services and lead agency. what we're looking at here are, what are the case management issues? Is HHS doing their job or not doing their job? So maybe we have lack of information on whether progress is being made. Or maybe there's been a lot of worker changes on a case and we feel it's impacting the case, and that's a barrier. I think a big one we're gonna find is the next one, the family finding and relative identification. We haven't found them. Nobody's done it. Nobody can show us that they've tried to look for a family. Or the non-custodial parent hasn't been located. And then we're looking at whether adoption paperwork complete. I mean, you can go down the list, but that's really what case management functions have not been done that are a barrier to permanency for this child.
So on the plan, do you just, when you're looking at either primary, concurrent, or both, you write that in, like primary or?
Right, you would just check. So,
Well, you have to know which one.
Yeah, that's what I'm saying.
oh, which one?
You want to mark
Is it
the
a
one
barrier?
for primary and the one for concurrent.
Is it a barrier
So
to
then
which
do you
one?
just put in P or C, see what I'm saying?
Right.
Oh, I see, yeah.
You said you have to find for
I would do
both
P or
now.
C.
Okay.
Yeah.
And
put-
keep in mind, it's gonna be the review specialist. This should help drive your conversation at your board meeting, for discussion purposes of where you wanna make your recommendations. But this is part of a 7-page document that the review specialist will be completing on the case and bringing that to the board meeting, and you'll help her fill that out.
So you guys won't necessarily sit and fill this out. It is to help, like Mary said, to guide. But if it's helpful, the review specialist will have it there. So as you're doing it, you're gonna be,
Oh, this isn't gonna be the one with our.
no, this is not. This will be attached to the data form, like Mary said,
I get it.
that Tony completes for each and every child reviewing. And it's like a 6 or 7-page data form, where we're looking at education and psychotropic meds and all those other types of
Right.
things. Okay, so then we look at placement, if you think placement is a barrier. If there's any policy or systems issues, one thing we're starting to see in more and more cases are adoption subsidy issues and guardianship subsidy issues. In other words, that foster parent has said, yes, I'm willing to adopt, or yes, I'm willing to provide guardianship for this child, but the amount that I'm going to get as a subsidy is a lot less than I'm getting as a foster parent. What is my motivation then to do a guardianship if I'm getting less money? The other important change that came into the system as of July
Doing the
1st,
right thing, maybe.
Yeah, and sometimes they just really can't afford it.
Right.
We've had one where that's been held up for a couple of years now because she says she can't live on that lesser amount of money. She's a
Right.
single parent, she doesn't have much income, and she needs that income.
yeah, part of it is too, the other major change that came in as of July 1st that is with Medicaid. It used to be prior to July 1st, if you had a subsidized adoption, that youth was qualified for Medicaid. Not anymore.
That all changed.
It all changed because July 1st, once you do an adoption, even a subsidized adoption, they have to look at the income of those adoptive parents on whether or not they are eligible for Medicaid. And for all of us sitting in the room, we know we could have wonderful insurance, but that mental behavioral health part of our insurance is usually not very good. And so losing that Medicaid, we're seeing is starting to impact permanency and adoption, because I may really want to adopt this 14-year-old, but I know they have severe mental and behavioral health needs, and I know my insurance is not going to be able to cover it. I need some help, but I have too much income, I'm not going to qualify for Medicaid. So how are we going to help solve that? So that's why we've added those policy issues there, because if they're coming up, we as a system need to take a look at that, how we're going to assist, because that's not fair to the child. And then, of course, they will also, our review specialists will be looking at court and legal issues. As I said, I'm going back to the very beginning when I started. We have various systems. We have not, as an agency, always provided great oversight onto the court or judicial system. And we know if a case goes on appeal, the average appeal time is 11 months, and that's the median time. That means half of them are more than, half of them are less. That does affect permanency. Not saying it, maybe the appeal was appropriate. That might have affected permanency.
What does this one mean, exception to guardianship, you know, the child not being? We're not supposed to approve guardianship under what age?
Well, HHS now kind of got rid of that.
Well, they did.
Yes. that HHS will do guardianship. We just did one in Northern Service Area of a 2-year-old.
2-year-old.
But that exception had to go through the service area administrator in order for that guardianship to go
How do you
through.
justify that?
The reason being is the child was placed with grandma and grandpa had a record, and so they were concerned about the adoption going through because of the record, and it was not a pretty record, so they did a guardianship instead, and it was not our recommendation.
Yeah, it wouldn't be mine for a
But the judge did it.
2-year-old.
So there are situations like that. But no, any child under the age of 6, I think now, they need, HHS has to give an exception in order to agree to it.
Still, I thought it used to be like 12 or something.
You know, guardianships for me are one of those, I used to sit in court for many years and agree to them, but guardianships to me are a little scary
Yeah, 'cause
as
they
to
can
permanency.
They can just dump them.
You know, but I was amazed as we're working on this Barriers to Permanency project with Eastern Service Area, how many adoption youth are coming back into the system.
Yeah, you're right.
And then the adoptive parents are walking away.
Yeah.
They just say, here,
Because,
because of mental behavioral health needs.
they didn't know what they got into, or they just
Well,
changed.
kids change. When they get
Kids
to be
change.
teenagers, some of them turn into
Yeah.
monsters. I had one to do that. It's just crazy.
You know, if they're born into your family, that's-
They're born into your family, yeah.
I guess you can walk away,
You can walk away.
but adoption is supposed to be fun.
Right.
Goes there.
This goes
Right.
back to that
It's
safe
like people
haven
that
stuff
get
we heard
dogs.
so much about a few
It
years
goes back to
ago.
safe
You
haven.
know, throwing
So
out.
any questions about the recs and findings, the barriers to permanency? I've got a couple of more minutes just before we're done. A couple of quick topics that I want to bring up. The other change that we will be doing January 1st, because all this goes into effect January 1st, I think some of our review specialists, even during the month of December, are going to use the new recs and findings on one case just so that we can all get used to it and see and practice it, which I thought was a very good idea. Right, so I think they will be doing that on maybe one case and doing both just so that we can get a feel for it, and they can get a feel for it along with all of us. And the barrier changes, that form all goes into effect on January 1st. And like I said, the probation review cases, we'll be changing that form. Our goal is to start looking at probation cases as of March 1st. Because I do feel these forms just, recs and findings will not work because we're looking at something very different. But what I was going to say too, one of the changes that we have done to the actual local board findings and recommendations is at the very top, on the second page where you guys talk about the current barriers to achieving permanency, we added a section that I really want the boards to start looking at, what are the strengths to achieving permanency? I think as a system, we always are looking at what are the barriers. I'm not sure we're helping the court or the parties to remember there are some strengths and these are the strengths. So we need to start pointing out at the very top,
We try to do.
what are the strengths? Because I think there are always strengths. Especially with some of these kids, they do have strengths. We're just not always pointing them out.
Right, we should focus so much on
We focus on the weaknesses and not the strengths. So we need to, as a system, really start looking at the strengths too.
Where are you finding that?
That's not on there. No, that's not in there. That's on the final board and rec finding. The other area I just briefly want to talk about that we're developing a process for too. As of July 1st, there was a change in the law with regards to youth aging out of the foster care system. They call it Foster Care to 21 or Bridge to Independence. It is a service that is available and funding available for youth at age 3A, abuse and neglect youth that age out of the foster care system. It can provide them with financial assistance until age 21. They have to do a number of things. They either have to be a full-time student, either getting their high school diploma or college, or trade, or be employed 80 hours a month.
Is that what Amanda Gill
And
pushed?
Right, Amanda McGill pushed that way. Right. Now, they figured that most of these youth, they figure about 90% of these youth will qualify for 4E funding. Because they're not gonna have income, they're 19, they're like most 19-year-olds, you don't have any money. That they're qualified for 4E, being they will be qualified for 4E under Nebraska statutes, we will be reviewing these kids. So we'll also be working on a process on how we're gonna review these 19, 20-year-olds.
Like we used to call the former ward program.
Former road
What
pro.
did you say besides if in school or working 80 hours a month?
Or because of some mental or physical disability, they cannot do either one of those. The other thing that is considered going to school or being employed is if they're in a work program like Job Corps or any of those, because they are trying to learn a trade to do something, so that would all count. I think it's a wonderful thing for the system. I think we will do and serve these young adults much better. Former Word program had some very strict guidelines on it that not a lot of students qualify. The other big difference with foster care to 21 is that the youth can come in and out. With Former Word, once you were off the program, you were off. But with foster care to 21, saying I'm 19 and I'm gonna go to college and I go that first semester like some of them do, and I get my payment and you know what, it didn't go very well. I'm gonna take a semester off, but then I'm gonna go back in the summer or the following. You can then get back on the program and they can be back helping you. A lot of kids do that and it's not unusual, but under Former Ward, once you were off, you were off. But this allows them to come in and out and to be back on and off the program as they need it and as they're meeting the requirements. So that's a good thing. So we will be working on a process too on how we're gonna review those cases. Because again, it's a different review. We're not looking at permanency objectives. We're not looking at, progress on a case. We're looking at, is a kid young adult getting the services they need, and is HHS providing that services? It's really not case management. It's not compliance driven. It's, are they working together to help that youth? So we're working on what that process is gonna look like too. So we've got some other, exciting changes coming in the next 6 months that we'll be working on. But we wanted to start with abuse neglect cases. So any other questions? Guys, I'm pretty much on time.
That was really informative.